Hi, everybody. I'm Neil Greenbaum. Thank you so much for joining me today. I really appreciate it. So I'm going to talk today about the 5 common mistakes that people make with their business and how to avoid it. So I already have a message from somebody. Okay, great. Thank you. So I'm an attorney. I've been an attorney for 25 years, which means, of course, that I graduated law school when I was 11. And I'm a transactional attorney. I deal mostly with buying and selling of commercial property and businesses and with drafting documents. Operating agreements, shareholder agreements, joint venture agreements, anything that really has to be drafted or edited. And I've also been involved in business before. I've been in the hotel business. I've been a real estate developer. I've owned a restaurant. I owned a software company. So I've been on the other side of the fence as well. And I've made mistakes, believe it or not, I have. And I try always to learn from my mistakes. Like, you can keep making mistakes. It's okay, as long as you learn from them. So what I'm going to try to impart today is some of the things that I've seen clients do and some of the things that I've done myself and ways to avoid them. It's simple not to get into trouble, but it's also simple to get into trouble. You have to really set things up properly and be ready for them. So this webinar is going to be 45 minutes of that, and I hope it's going to be educational, informative, maybe even entertaining, and I hope you get something out of it. So let's talk about who the webinar is for and who it's not for. So the webinar is for anybody who may own their own business, either with partners or perhaps by themselves, and may have employees or may not have employees. And who's it not for? Okay, so it's really not for people who don't have a business yet, who are thinking of starting a business. I mean, they'll have a lot to learn if they watch the webinar, but I'm really gearing this towards people who actually have an active business. It's not for people who don't think anything bad will ever happen to them. Obviously, they don't have nothing to worry about. Okay. It's not for people who like to do everything by themselves. For instance, they can file their own taxes, act as their own attorney, perform their own root canal. I can't help those people because nobody can help those people. However, I do implore all those types of people to just stay tuned for 45 minutes because you might actually learn something and realize that this webinar is for you. Anyway, so hopefully we'll have some time for a Q&A at the end, and I really hope that you enjoy this. Let's just talk about your business. So business is good. You started the business. It's on track. You're making money. Maybe you hired some employees. But in the back of your mind, things are gnawing on you, that things might not be 100% correct. Maybe you're not doing exactly what you should be doing. Maybe your main distributor is your uncle and you have no written agreement. Maybe your employees, everything flies by the seat of their pants in terms of benefits or vacation days, and you have nothing in writing. I'm a big believer in specificity. If you want to avoid problems, be specific. If you want to have problems, be vague. That's why I like documents. I like things in writing, like an order to things, because when you have those things, you don't make mistakes. And when you don't make mistakes, things hopefully go smoothly. Anyway, I'm not a litigator. I'm a transactional attorney. I have nothing against litigators. They do serve a purpose. But I believe that when you go to court, it kind of defeats all the purposes of everything. So my point is that I believe that if you're going to go to court, there are certain types of people that go, I'm going to sue you. Well, if you sue somebody, you've already lost as far as I'm concerned, because litigation, and I've been involved in litigation, not as an attorney, thankfully, but as a plaintiff where I sued somebody, or as a defendant where I was sued. And litigation is very costly. We're talking tens, if not hundreds of thousands, or maybe millions of dollars. It's very time consuming. You don't get, a judgment the next day. It takes months or years, and it gnaws at you. It's very emotionally draining. It takes a long, long time. And the problem is that it consumes your entire life, litigation. Like, you could be sleeping in the middle of the night, you wake up and all of a sudden you're thinking about something. But if you plan ahead, that's why I'm wearing today's shirt. If you plan ahead, hopefully you'll be able to avoid some of those issues. Anyway, so most people don't prepare. That's the problem. You can prepare for contingencies, but most people actually don't do it. And why don't they do it? So they don't do it because they don't want to spend money. And I understand people don't like to spend money, or if they ignore it, maybe it'll go away. Or if they do it themselves, maybe they'll be able to do it on the cheap. Sometimes they're too busy and they wait until actually it's time to get a lawyer. And the problem is by then it's too late, because everyone likes 10x. Oh, I can make you make 10x revenues or 10x profits. Well, my own personal 10x is that if you wait until you actually need something, it'll cost you 10x as much. But if you take care of it in advance, you really save a lot of time, money, and headache. Also, procrastination. If you have a headache for 6 months, you don't ignore it and it goes away. You go to the doctor immediately. So the same thing, if you know that something's wrong with your business, you take care of it now. You don't wait until it's too late. And a lot of people also are scared of dealing with lawyers, and I understand that. Listen, I know I instill the fear of God in most people, but the point is there are lawyers out there who you can deal with, who are human and really can help you out. So let's talk about the 5 mistakes that can destroy your business and how to avoid them. So the first one is, now it's not in any order of importance, okay? Actually, the first one is kind of my favorite because it's so stupid that people do this, and I'm going to go on a little bit of a rant. and that is do-it-yourself legal forms. Now, we live in a do-it-yourself world where nowadays, you can go on Google or watch a 5-minute YouTube video and be an expert at something. And so many people go and they do their own do-it-yourself legal documents. And 99% of the time, these documents don't work. I have my notes, I'm sorry. I don't know this by heart. So 99% of the time, people go and they do the wrong thing and they mess themselves up. Now, there's a few reasons why you don't want to do it-yourself legal documents. Yes, you're going to save money, but I'm telling you, the money is not worth it on the back end. One, there's a false sense of security. Okay, so like when you go on vacation and you get a great car rental deal and you're paying like $20 a day, you get to the counter and they go, oh, do you want insurance? And you're like, oh yeah, how much? And they go, $30 a day. And you're like, oh, no, I don't want insurance. So then you're really careful when you drive the car on the vacation because you don't have insurance. But if you get the insurance, you might be a little more freewheeling. Well, with a do-it-yourself legal document, you have a false sense of security because what you do is you think you have something that's going to protect you and it's not going to protect you. I'm going to tell you a quick story about a woman. She called me. She had an operating agreement. She wanted me to review it. So she sent it to me. And like within a minute, I'm like, okay, you drafted this yourself, right? Yes. I go, it's not really good. She goes, I don't care. I want to make sure that this guy, John, doesn't own any piece of my business. So I looked through the document with her. I'm like, oh, here's the members. John, 33.3%. John owns 1/3 of your business. Well, she goes, I don't want that. I go, well, you drafted this, right? Yes. You wrote John's name. Yes. You wrote 33 1/3%. Yes. You signed it. Yes. John signed it. Yes. John owns 1/3 of your business. Like, what were you expecting? She's like, well, how can we change that? I go, well, we can. We can't erase it or delete it, but what we can do is we can have him assign or transfer his interest to you. Okay, great. So she says, can you do that? I go, yes. I quoted her a flat fee. It was very reasonable in the circumstances. And she said, no, I'll just do it myself. I mean, you'll do it yourself. You got into this whole problem because you did it yourself. So the cure is going to be the same thing as the cause. I mean, that's like somebody's drowning. You don't give them a life preserver. You just throw them a cup of water. It's not going to help you. Needless to say, she went on her own and never heard from her again. It's fine. I hope it worked out for her. But the point is, like, there's a false sense of security. Second thing, and I'm going to use a prop on this one. Now, I'm known for wearing t-shirts. It just happened over time. But here's a t-shirt that I'm not going to be wearing, okay? Not because it's pink, because I'm perfectly, comfortable in masculinity, or it has a ballerina. The reason I'm not going to wear this shirt is because I look ridiculous in it, because it doesn't fit me. Now, why doesn't it fit me? It doesn't fit me because it wasn't made for me. When you go online and you take a do-it-yourself, fill-in-the-blanks legal document, it wasn't made for you. You might have 3 partners and 7 employees, and that's a document that's for somebody who has no employees or no partners, and it's not going to be the right thing for you. So the point are, I think that you have to make sure the document is written for you, because if it's not for you, it's going to go against you. And remember, this is your business we're talking about. These are legal documents that are important, and they serve a purpose. And if you're going to use a do-it-yourself, fill-in-the-blanks document that was made for somebody else, it's going to be to your detriment. Also, the forms tend to be extremely simplistic, or they're inferior quality. This happens all the time. I need a form for X. I need a form for Y. But the problem is these forms aren't really made for what you need them to be made for. I remember somebody said, I want to take my company public. Does anybody have a form? Like, taking your company public, you better have a lot of revenues, a clear path, hopefully, towards profitability, and be ready to spend 6 figures on legal and banking fees. There's no form to take your company public. It's like saying, I want to build a nuclear bomb. Does somebody have a recipe? It's not a cake. I mean, there's a certain level of complexity that you need. And if you do it yourself online, fill-in-the-blank legal forms, you're not going to have them. And it's going to be a detriment to your business in the end. It's going to cause you problems. Okay. Hold on. Someone's sending me a message. Okay, fine. Anyway, sorry about that. So also, you have to work by yourself on these documents. They're not like ready for you. You have to actually complete them. And I read this statistic that 80% of the people who do it-yourself legal documents make mistakes. Now, if you knew there was an 80% chance of rain, would you bring an umbrella out with you? Yes, of course you would. So if you knew there's an 80% chance that you'd make a mistake, would you do it? I would hope not. This is your business we're talking about, remember. Okay, they even tell you that you should use a lawyer. It's their way of covering the behind. I mean, these companies are out to make money. We know that. And they can't give you legal advice. And they say, we're not a lawyer. And this, I took it from one of their websites, the terms of service. These documents are not guaranteed to be correct, complete, or up to date. That's like saying, like, our pizza is not guaranteed to taste good or to satisfy your hunger. I mean, why would you do it? You wouldn't do it, right? So the point is, I was just asked to speak slower. That's one of my problems. I'm a very fast speaker. So the point is that do-it-yourself legal documents are a detriment, okay? Because you're not really paying for anything important. And you need, if you don't have any documents and you've used do-it-yourself legal documents, you really need to have a document audit, a legal document audit. And I'll discuss that later. And if you ever went to or paid attention in high school English, that's called foreshadowing, where I'm going to talk about something in the future. So the first thing that can really destroy your business is do-it-yourself legal documents. They're not made for you. They're probably not right. They're not complex enough, and they're not going to do the job. And 99% of the time, they're wrong. And I really suggest whatever money you think you're saving by using do-it-yourself fill-in-the-blanks online legal documents, I promise you, you will spend a fortune later correcting it. A fortune. Anyway, the second thing is, And to me, this probably is the most important, not structuring or operating your business correctly. Okay, so this is non-negotiable. When you go into business, you want to make sure to separate your personal assets from your business assets. It's extremely important, because if not, if there's any liability incurred by the business, it will sink you personally as well. So we have this like gift that allows us to do it. You can use either an LLC, which is a limited liability company, or you can use a corporation, which is another entity. And they're basically interchangeable. Some people pick one over the other. A corporation is more complex. It requires a board of directors. It requires annual meetings. It requires bylaws. But they do the same thing. They limit your personal liability, separate your personal assets from your business assets. I'm going to give you an example. Let's say you own a business personally. You did not form an entity, and it incurs $100,000 of liability. So the creditor wants to come after you. The business only has $50,000 worth of assets. So they have a $100,000 claim. They come after the business. They sink the business because only $50,000 of assets. But you own the business. So they want the other $50,000. They're coming after you. Now, they're coming after you personally, your house, your autos, your art, fur, jewelry, heirlooms, whatever you have. It's your personal assets are on the hook now. Now, if you go and you open up an LLC or a corporation, which is not expensive, it's a few $100s to open it. And if you do the documents right, perhaps a couple $1,000, okay? What you'll do is you form let's call it an LLC, ABC LLC. And that's going to own your business. And your business incurs $100,000 of liability. So the creditor goes after the business, and there's only $50,000 of assets there. So, okay, the business is done. Fine. They want the other $50,000. Let's say, for the example, you're worth $50 million. They're not going to be able to come after you because you personally do not own that business. ABC LLC owns that business. And because of that, it limits your liability. That's the whole purpose behind LLCs and corporations. If you run a business and you don't have an LLC or a corporation owning that business, I implore you, when this is over, just take care of it immediately. I mean, it's the smartest thing. It's crazy not to do it. Okay. So the process of forming an LLC or corporation is fairly simple. Well, you have to go to the state and you have to file a certificate of formation of incorporation or whatever it's called in the state that you're in. You get an EIN number, which is basically a social security number for a company, and you have some kind of operating agreement. Okay. So somebody just told me they just got the t-shirt. Great. Thank you. So anyway, you have some kind of operating agreement, either shareholder agreement for a corporation or an operating agreement for an LLC. Now, it's imperative that if you have more than one business, you have one entity per business. A lot of people think they're smart. You know what? I'm going to save myself some money. I'm going to form one LLC, and I'm going to run a bunch of different businesses under it and do it that way. Okay? So the thing is that if you do that, you run into something called cross liability. And I always say, listen, if you're going to spend an extra couple of $1,000s on each business forming and these entities and having the documents, you're going to be far better off. I'm going to give you a great example why. Let's say you have two separate businesses, okay? One is a driving school and one is a bakery. Now, in this example, the driving school will probably incur more liability than the bakery unless it's a really bad bakery. So what happens is that you form one entity, ABC LLC. So ABC LLC owns a driving school and a bakery. And the driving school incurs $100,000 of liability, but only has $50,000 of assets in the driving school. Well, they don't care about the driving school. They're going after ABC LLC because that's who owns the business. But ABC LLC also owns the bakery. So if they get $50,000 from the driving school, they can get the rest from the bakery. If the bakery only has $50,000 in assets, both your businesses just went under because you had them in one LLC. But let's say you spend a little more money and you form two LLCs. ABC LLC will own the driving school and XYZ LLC will own the bakery. So then the driving school incurs $100,000 of liability. They sue ABC LLC, which owns the driving school. There's only $50,000 of assets. They sink the driving school, fine. The bakery has $5 million of assets, but they can't go after it because it's owned by a separate entity, XYZ LLC. The bakery is safe. So if you form a separate entity for every business you have, that's the way to do it. So it's not just forming an entity that's enough. You can't just go out there and form an entity, an LLC or corporation, and say, okay, now I can do whatever I want. You have to operate it the right way. If you don't operate it the right way, you're going to get into trouble. So there's something called piercing the corporate veil. I know that sounds like an episode of Game of Thrones, but piercing the corporate veil is when a creditor or somebody plaintiff tries to get past the protection, the limited liability protection of an LLC or a corporation and go after you personally. Okay, so there's a few ways that they can do this. Remember that what they're trying to prove is that your LLC or your corporation is just an alter ego of yourself. It's a sham. It's there solely to try to protect yourself, but it doesn't really do anything. So the first way that you can get in trouble if you're not operating your business the right way is commingling. If you have a business and you have your personal assets, you have to keep them separately. Separate bank accounts, separate credit cards. You can't like pay your mortgage from your business account or deposit business checks into your personal account or vice versa. That's called commingling. That's probably the number one way you're going to get into trouble and allow somebody to pierce the corporate veil and go after your personal assets. Another way is fraudulent conduct. If you commit fraud, they're going to be able to pierce the corporate veil. So I suggest if you want to go into fraud, don't worry so much about an LLC or a corporation. You know, when you get caught, you're going to be done anyway. The last way is personal contractual guarantees. I see this a lot. This happens with people who take out commercial space, like they rent a retail store or perhaps an office or a warehouse. And even though their LLC or the corporation is a tenant of record and the lease is signed in that name, the landlord wants a guarantor and they sign and guarantee the lease. By doing that, you're on the hook now. So I always warn people against guaranteeing leases. And if you have to guarantee a partial amount or up to a certain amount or up to a certain amount of time, always try to limit your guarantee. So if you form an entity, okay, and you operate it well, then you're going to be okay. Now, if you don't have an LLC or you don't have a corporation, you need one ASAP. If you have either one of those, but you don't have an operating agreement or a shareholder agreement, you need one ASAP. And if you have them, but you draft them yourself and you know they're really not so good, you need to have some kind of legal document audit. Okay, we'll discuss that at the end, like I said. So the third mistake that could destroy a business that you really should try to avoid is not getting things in writing. So listen, handshakes are for introductions and congratulating people. And actually nowadays they're not for anything, right? We're not shaking hands. And I guarantee you that if you do business on a handshake, you and that person will have another kind of hand gesture between each other in the future. You can't go according to handshakes. You have to put things in writing. So that doesn't mean that you don't have a contract because things aren't in writing. For a contract, you need three things. This is like law school 101. You need offer, acceptance, and consideration. So I'll give you an example. Let's say that you want to buy my car. So you say, all right, Neil, I'll offer you $5,000 for your car. I say, fine, I'll take it. That's the acceptance. And the consideration is the $5,000. Okay? And later that day, you come by to my house with $5,000. I'm like, oh, I sold it to the guy down the block. Well, you would have a claim for breach of contract against me. But because we had an oral agreement or verbal agreement, what you'd have to prove is that we had a contract, what the terms of the contract were, and that I breached it, okay? But if we had like a piece of paper that said, you know, that you're going to buy my car for $5,000, I'm going to sell it to you, and we're going to close it on this day, then the document would speak for itself. You take the document to court, it proves that there's a contract, it tells you what the terms are. All you got to do is prove that I breached it, which you can do by getting me to testify that I sold the car to somebody else and getting the person who bought the car to testify that they bought it from me. So the thing is that if it's in writing, it just makes things much more clear. Now, there's something called the Statute of Frauds that applies to a few things, particularly real estate. If you ever went, and it says that for real estate, things have to be in writing. Now, my own personal opinion is that everything should be covered by the Statute of Frauds, but that's not the way it is. If you ever went to make to an open house and wanted to make an offer on a house, you know, the real estate broker comes over with papers like, sign this. And the reason they do this is not because they're pushing, which they are, but the reason they do that is because it has to be in writing for real estate, or else it's not valid. It's not a real contract. So the same example with the house, with the car, if we apply it to a house and you want to buy a house for $100,000, I said, okay, we shake on it, but of course shaking is not necessary. And then you go on your way and you come by later to close on the house. I sold to the guy down the block. You're going to say, well, I'm going to sue you for breach of contract. You can't, because it wasn't in writing. And when real estate statute of fraud applies, it must be in writing. Anyway, so now that you know that things should be in writing, how does that apply to your business? Well, there are certain documents you must have for your business, okay? So if you have an LLC or a corporation, for an LLC, you must have an operating agreement, or for a corporation, you must have a shareholder agreement. Now, the reason you're going to have these is because if you have partners in your business, you're going to get into a dispute with them over things. I don't care if it's your spouse, significant other, fraternity brother, bridesmaid, whoever you're in business with, you're going to fight with them. Trust me, there are a lot of litigators out there. I know they make good livings off of people fighting over money in business, okay? So if you're going to get into a dispute, you might as well have a document, an operating agreement for an LLC or a shareholder agreement for a corporation that lays out what you should be doing. It lays out how you distribute funds. It lays out about a buy-sell agreement. Everything that you might be fighting about is in black and white, and then it's there. Okay, so that makes sense for a corporation or an LLC where there are multiple members and multiple shareholders. But you might be saying, well, if I'm the sole shareholder, the sole member, why would I need an operating agreement or a shareholder agreement? And the reason is piercing the corporate veil. If you and I do business, and I believe that your LLC or corporation is a sham, and it's an alter ego of yourself, the first thing I'm going to do You say, okay, you know what? Let me see a copy of your operating agreement or your shareholder agreement. And you're going to be like, how many? I don't have one. Well, then I say, oh, really? So you're saying that your LLC or your corporation is legitimate, but you don't have the single operational foundational document for it? Well, it's going to help me pierce the corporate veil and go after you. So even if you're a single member LLC or a single shareholder corporation, you must have an operating agreement or a shareholder agreement. So what are the documents would a business have to have? In my book, the restrictive documents, usually 4 types of restrictive documents. The first one is a non-compete agreement. If you have employees or partners who are leaving, let's say you're buying out a partner or an employee is quitting or going somewhere else or whatever, you don't want them to take all the knowledge they learned from working in your business and go across the street and open up and compete with you. I mean, that would be stupid. That would sink your business, right? So what you do is you have them sign a non-compete. And the non-compete will hold up so long as it's reasonable under 3 scenarios. It has to be reasonable in terms of time. Like you can't say, you can never be in this business from now until the end of eternity. No, it has to be reasonable, a year or 2, let's say. It has to be reasonable in terms of geography. You can't run that kind of business anywhere in the stratosphere. No, that would not be reasonable. But if you said within 10 miles of our business, that would be reasonable. Or perhaps in scope, you can't do any kind of business that sells something to the public. That's not reasonable. It has to be whatever, let's say we had a bakery business, you can't sell baked goods to the public. Okay. So a non-compete is extremely important if an employee or partner leaves a business, that they don't compete with you, because that would certainly hurt you. Next would be an NDA, or a non-disclosure or confidentiality agreement. You might share proprietary non-public information with somebody. It could be an employee, it could be a partner, it could be somebody that you do business with, okay, like an independent contractor. And you don't want them to go out and leak that information to everybody. So what you do is you have them sign an NDA or confidentiality agreement, and thereby they're forestalled for doing so. 2 other types of restrictive documents would be a customer non-solicitation agreement. Your customers are important. And if somebody gets wind of who your customers are and decides that they're going to solicit those customers from you, it's going to affect your business. So what you do is with employees or with partners, with other people you do business with, let's say third parties that you do business with, you have them sign a non-solicitation agreement. And you can even list your customers and attach them as an exhibit, and they can't go after those customers. And the last type of restrictive document would be an employee non-recruitment agreement, which would be the same thing as soliciting your customers, but for recruiting your employees. Your employees are important. You've trained them. They do things the way you want them to. You don't want them to now go to a competitor or go to somebody else and work against you. It's only going to affect you and your business in a negative way. So the only other documents that I want to discuss that you definitely need in writing, and I'm going to get to it in a second as well, are employment-related documents. If you have employees, you should have employment agreements and employee handbook, and I'll describe why later. Or if you have independent contractors, you should have an independent contractor agreement. Okay, I have a link I just wanted to put in the chat. Let me just see. Yeah, I'm not sure if everyone had that, but in case you didn't, now you do. Okay, so if you don't have these important documents in writing, you need them. Okay, and if you have them, but they're not good, you need to have some sort of legal document audit to go over those documents and make sure that they do what you need them to do. Okay, anyway, so the next thing is the 4th thing, that common mistake that can destroy your business, is failing to protect your business's intellectual property. So intellectual property is very valuable to a business, and sometimes it's the most valuable part of your business and you don't even know. Now, intellectual property would be something that you create. There's 3 main types of intellectual property. There are patents, trademarks, and copyrights. So patents is some type of invention, and it doesn't give you the right to do it. It excludes others from doing it. If somebody's going to use your intellectual property, you might as well be compensated for it, because there's a real value to it. So what's going to happen is, if you have a patent, an example of a patent would be, let's say, the light bulb. Well, who patented the light bulb? Thomas Edison, right? Or the iPhone. Who patented the iPhone? Apple. So I can't just go and make my own iPhone and call it the Neil phone and sell it and be the same thing, because Apple's going to sue me. They have a patent for it, and I understand that. So you want to exclude others from using things that are patentable. And if you have a patent, then there's a value to it. And sometimes the patent or any intellectual property is the majority value in your company. When you sell your company, people are buying your company for that intellectual property. Okay, so that's patents. And there's trademarks. Trademarks is a word, name, phrase, symbol that has something to do with your brand or with a product that you sell. So Google, Walmart, Apple, these are all trademarks. Nike. Okay, so here's three trademarks that everyone knows about Nike. The name Nike is trademarked. Their logo is the swoosh. That's trademarked. And their tagline is, just do it. That's trademarked. If I said, oh, Neil Greenbaum law, just do it, I guarantee you I'm going to get a letter from Nike's attorneys telling me that I'm infringing on their trademark. And it's important because those trademarks have great value to them. So when you file for a trademark, there are different classifications. That's why you have certain companies that have the same name and they do totally different things. You have United Airlines will fly you somewhere, but not so much today. And United Van Lines will move you from house to house. So they're probably not a law today. Delta Airlines, Delta Faucets, which makes like kitchen and bathroom faucets, Delta Dental, which is a large dental practice, Apple Computer, or Apple Records, which was the Beatles' Apple record company, even though they did sue each other, Domino Sugar, Domino Pizza. Okay, anyway, the point is that if they're different classifications, it's not a problem. So those are trademarks. The third one is copyrights. Copyrights is protection to original works of literature. Harry Potter is a copyright by J.K. Rowling. It's worth billions of dollars. A song by the Beatles would be copyrighted. And in business, code. If you make an app or you're in software, a code is something that's copyrightable, and you want to be able to do that. So intellectual property can be very valuable to your business. And it's extremely important that you protect it. And how do you protect it? Well, you'll file for a patent, or you'll register a trademark or register a copyright, okay? And it's important that that the company owns it. This is important. Okay, so let's say you have a company, you form a company. I'm gonna give you two examples. So they're really good. The second one's great. You form a company with two other people. One person wrote code. It's a software company, okay? And he copyrighted the code for himself, okay? Then somebody puts up the money, and you're operating the business, right? The problem here is that the code was copywritten by that guy, let's call him Ralph, before you started the business. But you go into business and things are great, and then a couple of years down the road, somebody wants to buy your business. And what happens? When they're doing their due diligence, they say, hey, you know what? Your company doesn't own the intellectual property. Ralph owns the intellectual property. Now, Ralph is really thrilled, but of course, under the circumstances, the odds are that the company will be able to get it. But the point is that Ralph never transferred his intellectual property to the company. You need an intellectual property assignment, okay? So it's important that if you have intellectual property, if you have employees or independent contractors or partners, or anybody who works in your business, they have to have an intellectual assignment, an intellectual property assignment where they assign their rights to the intellectual property to the business. And under those circumstances, Ralph should have done that, so the business owns the intellectual property. Okay, so here's a good example. There's a guy named Arthur Fry. Most of you never heard of him. So Arthur Fry worked for 3M Corporation. And I'm using another prop. Arthur Fry was in a church choir, and he had a hymnal which had all the hymns, and he would put pieces of paper in the hymnal so he knew which hymn to sing. You know, they would always fall out. So then he went to one of his colleagues at 3M, a guy named Spencer Silver, and someone just told me what it is. Yes, I'm about to say the story. And he went to this guy, Spencer Silver, who had created an adhesive at 3M. And he said, you know, let me borrow that adhesive and attach it to a piece of paper. And the only color paper they had in the office that day was yellow. He attached it, he put it in his hymnal, and he invented the Post-it note. Now, the Post-it note is one of the greatest inventions of all time. I'm sure it's worth billions of dollars to 3M. You think Arthur Fry is a billionaire? I don't think so. You know why? Because Arthur Fry worked for 3M. I guarantee there was an intellectual property assignment. His job was to do things, and Spencer Silver was to do things like create things like that for 3M. That was their job. The value stayed with 3M, not with them individually. That's how you keep the value in your business. And if you don't have things like intellectual property assignments or intellectual property assignments or intellectual property cooperation agreements, where if somebody leaves, they still will cooperate with you in future intellectual property filings, then you're taking value out of your business. And it's a mistake. And ultimately, if you take value out of your business, you can destroy your business. So if you have intellectual property, you have to protect it. And if you have employees or if you have partners, if anybody who's working on intellectual property matters, you have to have an intellectual property assignment. So you have to have these cooperation agreements. They're imperative. And if you have them and you don't think they're good, they have to be part of a legal document audit. Okay, so here's the fifth common mistake that can destroy your business. And that's not adequately dealing with your employees. Now, I don't mean treating them nicely. You should treat everybody nicely, whether they work for you or not. But like they say, you know, the two best days in a boat owner's life are the day they get the boat and the day they get rid of the boat. Okay, so it's like that with employees. It shows you that your company has gotten to a level where now you employ other people. It's a great thing. However, with employees comes great responsibility, okay? Now, you have two types of workers. You have employees and you have independent contractors. And the difference between them is that the level of control you have over them. So where and when they do work, or how they're paid in reimbursements, or if they get benefits, or if there's continuity of employment. For example, if you hire somebody and you say, You can't just say like, payday's Friday, see you Monday, and we'll figure out what you do. It doesn't work that way. If you hire somebody and you say, you work Monday through Friday, 9 a.m. till 5 p.m. and lunch is 12 to 12:30, and this is what you have to be doing for us, okay? And you're going to get 2 weeks vacation, and we're going to cover your health and dental plan. That's going to be an employee, okay? Whereas someone else you'll hire and you'll say, I need you to do this. You have 2 weeks to do it. I don't care where and when you do it. You can do it 3 in the morning. You can do it in your bathroom. You can do it in Starbucks. I don't care. Just get it done. And once that project's done, there's not necessarily that you're going to hire the person to do something else. That would be an independent contractor. So what's the big difference between employees and independent contractors? The difference is that employees have bigger obligations. You have to do things like withhold income tax, pay Medicare tax, take care of Social Security, unemployment tax, offer certain types of benefits if you have a certain number of employees. So if you think you're smart, you can say, you know what? I don't want to do that. That cost me a fortune. I'm just going to call everybody an independent contractor. That's it. I give them 1099s. I'm not going to W-2 anybody. Now they're all independent contractors. Now I don't have to worry about benefits and Social Security and taxes and insurance and all that stuff, right? No, because if it's a duck, if it looks like a duck and it quacks like a duck, it's a duck. It's not an elephant, right? And you don't get to decide if somebody's an independent contractor or somebody's an employee, okay? The people who decide are the IRS and the Department of Labor, okay? And those are people you don't want to mess with. And if you misclassify purposely whether somebody is an employer or an independent contractor, not only are you going to have to pay back the taxes that you owed, you can be penalized and fined for it. Okay, so what happens if you, so you want to make sure that if you have employees or independent contractors, you have the right documents. For an independent contractor, what you have to do is you have to have an independent contractor agreement. You have to spell out what the person does, what their role is, how much they're getting paid, you know, when they have to do things by, et cetera. It's very important. Employees are more important because employees have more obligations. You have to have an employment agreement, okay? You have to, that'll spell out things like the compensation. It might even have those restrictive covenants like confidentiality, non-disclosure, non-solicitation, intellectual property assignments could be part of an employment agreement. You also want to have an employee handbook. An employee handbook is very important because you can't just expect things from people if you don't tell them what their expectations are, okay? And you want to put in writing, these are your vacation times. These are your benefits. You're all being treated the same. Because, you know, when it comes to employees, a lot of people think that maybe you're treating those people better than me, and maybe I'm part of a different class. And that could lead to problems where employees can sue you. But if you lay everything out on the table and say, everyone has the same vacation and everyone has the same benefits. And I mean, obviously not everyone's going to have the same salaries because you have different levels of employee. You're going to be able to handle things better. You're going to be able to avoid problems that are going to lead to litigation and you're going to get to court and cause all sorts of issues for you. So, you know, having written policies and written procedures and manuals are extremely important for your business. So it's important when you have an employee handbook that you do a few things. First of all, you have to give each employee a copy. And not only you give it to them, but you have them sign that they received it. Okay, and then you have to communicate certain things, like you should discuss benefits at certain times. And you never want to have a situation where an employee pleads ignorance of the matter, okay? So you want to implement the handbook, you want to follow it, and when the time comes, you want to revise the handbook. You want to make sure that it goes with the times. Listen, laws change, and it's important that, you know, that your employee handbook goes with the laws. I mean, right now, somebody mentioned about California. I know there's certain gig economy workers like Uber drivers. I think they're trying to make them employees, which would be very detrimental to Uber as a business. It'd be good to be drivers, but you know, there's a balance that you have to do, and I'm not a legislator, so I don't have to worry about that. But the thing is that if you have employees, you have to make sure to have an employee handbook. You have to make sure to have employment agreements. If you don't have them, you need them, okay? And if you have them, but they're not good, you have to have them looked at. It has to be part of like a legal audit document.